A former Director General of Federal Radio Corporation of Nigeria, Dr. Ladan Salihu, has knocked the Supreme Court for their verdict on the 2023 presidential election petition appeals. Dr. Salihu, a chieftain of the People's Democratic Party (PDP), said the ruling by the Supreme Court puts Nigeria on a very, very worrying map of global shame. On Thursday, the Supreme Court affirmed the election of President Bola Tinubu of All Progressives Congress, while dismissing the appeals by Peter Obi and the Labour Party and Atiku Abubakar of the PDP. But Dr. Salihu, while appearing on Arise TV, said the Supreme Court, by this aspect of the judgment, which is forgery, is literally relegating the Nigerian Constitution to the background or taking the Electoral Act to supersede the Constitution.
It is quite intriguing. It is quite not only disappointing, but it puts Nigeria on a very, very worrying map of global shame. Look, the Supreme Court, by this judgment, by this aspect of the judgment you just talked about, is literally relegating the Nigerian Constitution to the background, or is putting a kind of it's taking the electoral law to supersede the Constitution, the Electoral Act. And the Constitution of Nigeria 1999 is very explicit, is very clear, it is unambiguous. It states that forgery, any person who commits forgery is not entitled to run for a political office. And I'm not even bothered about whether or not President Tinubu attended, a university. He can have 1,000 degrees. But take it to the irreducible minimum. The requirement of the Nigerian Constitution 1999 states clearly that forgery is not to be tolerated. It's a crime. I'm just trying to perceive and to contain the anger from within. The Nigerian Constitution is very explicit on the issue of forgery. Once you forge a document and you submit it to INEC, you automatically should have been disqualified. And let me tell you, the appeal court, some days or weeks ago, actually quashed the election of a PDP member of a House of Representatives from, I think, Adamawa State, because he was found to have forged his certificate.
Well, to be entirely...
let me quickly finish.
Sure.
Look, in 1999, when President Obasanjo came on board as the president, you remember the case of Imam Buhari, Salisu Buhari rather, the Speaker of the of the House of Representatives. He was discovered to have forged his certificate. What he did was to dignifiedly step aside, and the country moved on. What I am worried is not so much because Atiku is not the president today. No, I'm worried for Nigeria, that has set a precedence that your child and my child, probably in the next 10, 15 years, he cannot aspire to any political office, or if he does so, heavens forbid, he can go to Owode and get a certificate that is forged, and it will end up in the same kind of quagmire that we have found ourselves today.
This interview is coming amidst Justice Musa Dattijo's revelation, exposing how corrupt the judiciary have become under Justice Ariwola, where nepotism, tribalism, and brigandage is the order of the day. He stated this while retiring from the Supreme Court after spending over 40 years in the profession. Here is in part what he has to say.
Appreciable efforts have been made by earlier speakers in telling you who I am. May it please you to hear it from the horse's mouth. I was born and bred in Lima, a ward in Mina, now the capital of Niger State. Then, in 1953, a relatively small and quiet provincial headquarters. I was named after my paternal grandfather, known and called Musa Kumuria. Adamu, my paternal great-grandfather, traded in cattle and kola nuts between Kumuria, a village in present-day Kano State, and Ogomosho in Oyo State and beyond. He would convey cattle southwards and kola nuts back to the north. They traveled on foot and in groups in those days, making stopovers at Bakani and Durban, both places along the route towards Moka and in between Kontagora and Bida respectively. Musa Kumuria's mother, Hafsatu, was Adamu's third and youngest wife. Before Musa's birth, her earlier children had died serially. On conceiving and determined not to lose Musa, Hafsatu insisted that she accompanied her husband on his trade surgeons. At Durban, on one of such occasions, Adamu fell ill and died. Hafsatu, rather than travel back to Kumuria, decided to settle at Durban with young Musa, whom she feared, like his deceased siblings, would also die if they went back home to Kumuria. Hafsatu remarried subsequently and had a daughter, Gogo Saidatu, Kumuria's uterine sister. Not quite long, she lost her second husband. Incessant pressure from Musa's uncles back in Kumuria made her to relocate to Paiko and hence to Mina. Musa, then a young man, joined the labor force engaged in the construction of the rail line passing through the town to Baro, a nearby village, as well as southwards to Lagos. With the successful completion of the construction of the rail line, Musa Kumuria settled in Mina into the grain trade. He married Hadiza, a young Hausa lady from Tawa in the present-day Niger Republic. They were blessed with 3 children. My father, Muhammad Najume, the second male child, was the youngest. Usman and Aisha were his seniors. My maternal grandparents were of the Fulani stock that accompanied the Amkodio jihadists to the Chief Justice of Nigeria is the chairman of the National Judicial Council, NJC, which oversees both the appointment and discipline of judges. He is equally chair of the Federal Judicial Service Commission, the National Judicial Institute, NJI, the Legal Practitioners Privileges Committee, LPPC, that appoints senior advocates of Nigeria. In my considered opinion, the oversight functions of these bodies should not rest on one individual. A person with absolute powers, it is said, corrupts easily and absolutely. As chair of NJC, FJSC, NJI, and LPPC, appointments as council, board, and committee members are at his pleasure. He neither confers with fellow justices nor seeks their counsel or input on any matter related to these bodies. He has both the final and the only say. The Chief Justice of Nigeria has power to appoint 80% of members of the council and 60% of members of the Federal Judicial Service Commission. The same applies to NGI and LPPC. Such enormous powers are effortlessly abused. I repeat, such enormous powers are effortlessly abused. This needs to change. Continued denial of the existence of this threatening anomaly weakens effective judicial oversight in the country. Now, by the provision of paragraph 20 of Part 1 of the third schedule to the 1999 Constitution of the Federal Republic of Nigeria as amended, the NJC shall comprise the following members: the Chief Justice of Nigeria, who shall be the chairman; the next most senior Justice of the Supreme Court, who shall be the deputy chairman, Regrettably, the next most senior Justice of the Supreme Court, like deputy governors of states, shorn of any official function except at the pleasure of the governor, is neither consulted on anything nor does he have any official function. His job as number 2 is purely as the CJ and pleases. It is incumbent that the system provides for more inclusion and consultation among the stakeholders. Now I move to the issue of funding and independence of the judiciary. Allusions have been made in innumerable times about poor funding and how the judiciary has been emasculated by inadequate funding. My Lord, the late Honorable Justice Mustafa Akambi, former president of the Court of Appeal, in a publication titled "The Main Obstacles of Justice According to Law," said, and I quote, "A good judgment flows from a mind that is not bogged by the thought of, where do I get my next meal? Or where do I get the money to pay my son's school fees? Poor conditions of service disturb the mind. It is an obstacle to clear and positive thinking. Beyond the issue of the salaries of justices remaining static with no graduation for almost 15 years now, it is instructive to inquire what the judiciary also does with its allocations. Who is responsible for the expenditure? An unrelenting searchlight needs to be beamed to unravel how the sums are expended. In 2015, when President Muhammad Buhari became the president, the budgetary allocation to the judiciary was 70 billion naira. In 2018, appropriation bills submitted to the National Assembly, the president allocated 100 billion to the judiciary. The legislature increased it to 110 billion, 10 billion above the 100 billion appropriated for the 2017 fiscal year. At the end of President Buhari's tenure in 2023, judiciary's allocation had increased to 130 billion. 130 billion. This is an increase from 70 billion to 130 billion in 8 years. The present government has allocated an additional sum of 35 billion naira to the judiciary for the current financial year, making the amount of money accessible by the judiciary to 165 billion naira. If one looks at what has been given to the states, each state was given 5 billion to solve its problems brought about by the conditions we are going through because of the fuel thing. If you look at what is given to the judiciary, and yet we are still saying that the judiciary is being emasculated, I think there is something wrong somewhere. More than 80% of the amount appropriated by the Ninth Assembly has so far been released to the judiciary. It is envisaged that the additional 35 billion naira will equally be released by the present government. I'm sure it will be released by the present government because I know the antecedents of Mr. President. Because when he was governor in Lagos State, I was privileged to be in the Lagos State Division of the Court of Appeal. And I knew his attitude towards the judiciary. I don't think he would be flippant to say that he's doing this and to recline from doing that. I'm very, very optimistic that that amount of money will be released to the judiciary as well. Now, notwithstanding the phenomenal increases in the sums appropriated and released to the judiciary, justices and officers' welfare and the quality of service of the judiciary render have continued to decline. There is a terrible decline in the services and the welfare of justices and officers of the institution. I should know, and I know, and I'm saying it as I know them. It may interest one to know that, and this is another ridiculous thing, that the Chief Registrar of the Supreme Court earns more than the justices of the court. It's not something of today. This anomaly has been in existence all these years. I was a Chief Registrar in 1986. I knew what salary I drew vis-a-vis what the judges of the High Court that I served were taking. Supreme Court is the apex court. And yet, the Chief Registrar of this court earns much more than I do, earns much more than we all do. And nobody talked. Nobody talked. While she earns 1.2 million a month, justices take home 751,000 naira in a month. The Chief Justice on his part takes home 400,000 plus. The Chief Justice. The salary of a justice, curiously, drops rather than increases when he gets the added responsibility of being a Chief Justice. That the unjust and embarrassing salary difference between the justices and the Chief Registrar still abides remains intriguing, to say the least. It is highly intriguing that this anomaly, we all know it, and nobody has taken it a duty to do something about it. Valedictory session after valedictory session, lapses and challenges that should be nipped are stated to no avail. Why the silence and seeming contentment? The process of appointment of judges and the quality of judgments of courts. A couple of years ago, appointment to the bench was strictly on merit, strictly on merit. Sound knowledge of the law, integrity, honor, and hard work distinguished those who were elevated. Lobbying was unheard of. Lobbying to accost justices into their chambers by people who seek to be elevated, that the judges should put in words for them, were unheard of. You will just be sitting, and if those who are given the responsibility of making the elevation find you worthy, you just get a letter to that effect. You wouldn't have gone to anybody to ask for any favors or recognition. But that is not the case today, unfortunately. I never lobbied, not at any stage of my career, to secure any appointment or elevation. And I challenge anybody to contradict this statement of mine. As much as possible, the most qualified men and women were appointed. That can no longer be said about appointments to the bench these days. The judiciary must be uniquely above board. Appointments should not be polluted by political, selfish, and sectional interests. The place of merit, it must be urged, cannot be overemphasized. Now I will move to public perceptions. What perceptions the public has about the judiciary. Public perceptions of the judiciary have over the years become witheringly scornful and monstrously critical. It has been in the public space that court officials and judges are easily bribed by litigants to obviate delays and or obtain favorable judgments. His Lordship Adolfo Okoji JCA, at the point of exiting, had enthused inter alia as follows. Please, I expressed everywhere by the generality of the public. He is one of us. The person making this observation was one of us. He says, please, I express every day by the generality of the public, begging the judiciary to be just, to be truthful, and to save the country from collapse. My question is whether the judiciary needs to be begged or cajoled. What is it that qualifies any person to bear that exalted name, Honorable Justice? Is it not for him to administer justice without fear or favor? Unfortunately, it has been severely vilified, with the apex court so denigrated and called by a social commentator as a voter gaggle of useless, purchasable judicial bandits. How did the judiciary get to this level?
Don't forget to subscribe to this channel for more on content like this. Thank you so much for watching. See you next time.